So challenges to wills. There's a number of ways that wills can be challenged. The first is lack of capacity, and this is where lawyers have to be really careful. If we've got any concerns that the person in front of us is not able to understand what they're doing or give clear instructions, or they've got some type of illness, then we have to be really careful making sure they've got capacity. Going and seeing a lawyer to make a will where capacity is perhaps a little dicey is hugely important, because we'll take a lot of steps to make sure that we do make that will as foolproof as we can. So we take videos, we ask a lot of questions, we sometimes get a GP or a geriatrician to attend the appointment. All of those things are to build a case so that when someone passes away and we know someone's going to be trouble, when they come out of the blue and say, Mum had no capacity, I'm going to challenge this will, that we've got all of those building blocks in place to actually rebut that. Undue influence is another one. So that is another way in which wills can be challenged, where somebody has been putting pressure on somebody to change their will, influencing them in a way where there's perhaps an abuse of power or trust. So we, again, have to be really careful of that. If you go along with we quite often have people bring their elderly mother, and we'll often say to them right from the outset, look, there's going to be a point at this meeting where we're going to need to sit with your mum on her own. And the ability there is for us to be saying is, you know, do you understand what you're doing here? You know, we're making sure that there is no undue influence. And again, taking those steps, we take a lot of comprehensive file notes so that if that was ever to come out, or later a challenge on that basis, we've got the records to say these are the steps we took. This last one's a funny one. No one really kind of thinks about this, and I got caught myself, didn't even think about it. When you get married, a will that you've prepared and signed is immediately revoked. So people think that they have got their wills and affairs in order, but they are completely revoked on marriage. So you have to be really careful about that one. We quite often, one of our questions in our wills list is, are you engaged? Are you thinking of getting married? What, you know, if you're in a de facto relationship, so that you can get around that if you have these lines in the will that say this will is made in contemplation of marriage. If you don't have those words, it's gone. And you're looking at an intestacy then, which Alana will have a chat to you about. So claims against estates, we've got three main pieces of legislation that we need to be aware of. We've got the Property Relationships Act, which is our act that provides rights to de facto partners, someone that you've lived with for more than 3 years, or that you have a child with if it's shorter than 3 years, your spouse, your civil union partners. So this piece of legislation has a particular part that deals with death, and it basically says on death, a spouse, civil union partner or de facto partner can choose one of two options. They take what you've left them under the will, or they have a crack and have a claim under the Property Relationships Act. So if you don't leave them enough, or you don't fulfil your duties under that act, then you're looking at possibly a Property Relationship Act claim. So we're really wary of making sure people understand those duties, but that's one to really be aware of when you're making your will. The Family Protection Act, this is a 1955 legislation, so it's super old, but the courts have just developed it over the time, and so it's a very, very widely used piece of legislation to challenge wills. So the Act itself, the terms are really simple. So a will maker has a duty to provide adequate provision for spouses, civil union partners, de facto partners that you were living with at the time that you passed away, your children, that includes adult children, even if they're financially independent, much more wealthy than you are, grandchildren, stepchildren that you might be maintaining, and parents with a limited ability also to claim. So this is the one that our litigators spend a lot of time in court. Actually, a lot of them don't end up in court, they get settled outside of court because it's so well established law that these claims are likely to be successful to a certain extent. So this is a key one. We get the client that comes in and says, I've got 3 children, one of my sons is estranged, I've got nothing to do with him, I want to cut him out of my will. this is the piece of legislation that we explain to that client. It's not a fait accompli. You can do things to get around this. You can transfer your assets into trust, which is a common way of getting around it, but it's really worth keeping in mind. So people will generally have a crack under that. The last one is another old piece of legislation. It's called the Law Reform Testamentary Promises Act, and this comes from the ages where we had landowning clients with quite a patriarchal kind of concept where they might have 5 sons, they all work on the farm throughout their life for pittance, and Dad's saying, look, I'll look after you in my will. Dad passes away and leaves the farm to his brother, and the sons are left. So the key thing here is there must be a promise to someone to leave them something in your will in exchange for services provided. So your lawyer will always ask you this: have you made a promise to someone that you're going to leave them something? People will generally say, oh yes, I've said that I will leave them my thimble set, and no, unless there is services provided in exchange for that promise, then there's no enforceability there. But again, the key with the lawyer there is that there'll be a questionnaire that we've filled in and said, I've asked this client whether there was a promise. They have said no, and that is evidence that is later used if an application is made. You can see after we've covered all of those claims and the little things that you have to take into account why legal advice is so important when preparing your will. It allows us to structure your legal affairs so that you can avoid those claims, and those claims are not only stressful but costly and damaging on relationships in the family.